On March 7, 2026, in the Lacey Municipal Court, Christopher Zahn faced arraignment on a simple assault charge filed by the city of Lacey. The allegations stem from an incident where Zahn allegedly fired a BB gun from his residence at William Lindquist, a jogger passing by on the sidewalk. Prosecutors claim Lindquist heard a projectile whiz past his face and observed a male figure in a window holding what appeared to be a firearm. The case presents complex questions about bail determination, release conditions, and how courts balance public safety against a defendant's financial circumstances.
Zahn, Christopher.
Your last name?
Zahn, Z is in zebra, AHN is in November.
Okay, Mr. Zahn. And Ms. Kamari?
Yes, Your Honor. I met with Mr. Zahn. We're waiving formal reading of the complaint. I've gone over his rights and he has no questions. We're stipulating to probable cause for purposes of today's hearing only and asking the court to enter a plea of not guilty. He currently receives disability and has no other source of income.
So, Mr. Zahn, you're charged with this allegation from March 7th of simple assault by the city of Lacey, and enter a plea of not guilty to that allegation. And then we'll appoint an attorney to represent you, find that you qualify for that. And from Pacific Point Defense. And then going to hear from the prosecutor and from Ms. Kamari on your behalf about release conditions and set a court date. So, Ms. Eddy?
Yes, Your Honor. The city's going to request a $10,000 bail based on the basis that the defendant is a likely danger to commit a violent offense based on his criminal history, the fact that he's currently on release conditions from last year for felony harassment, threats to kill, and assault in the second-degree strangulation, and makes kind of highlight those briefly for the court. Essentially, the victim in this case, William Lundquist, was, I believe, out running when essentially a shot went in front of him while he was, in theory, he heard a projectile pass his face, and he turned around and he saw a blue house where a person with the white trim and a male in the window holding what appears to be a firearm. And so he called police, and basically, essentially, investigation revealed that the defendant was in the residence. He wasn't coming out necessarily to speak with officers, but the defendant's father, Clyde Zahn, came out and spoke with officers. And so the officers obtained a search warrant and searched the residence and located a BB air gun. And officer also located some projectiles for an air gun pistol being shot at the victim while he was running by on the sidewalk.
The arraignment proceeded with Zahn's attorney stipulating to probable cause solely for the hearing's purpose while entering a not guilty plea. The prosecutor then requested $10,000 bail based on Zahn's criminal history and pending felony charges, while defense argued for personal recognizance release due to his financial hardship and mental health treatment. Under Washington State's bail framework, Revised Code of Washington 10.19 requires that bail be set at the least restrictive amount necessary to reasonably assure the defendant's appearance and protect community safety. The Washington State Supreme Court in State v. Blazina, 2015, emphasized that courts must consider a defendant's ability to pay when setting bail, recognizing that excessive bail effectively constitutes pretrial detention without proper procedural safeguards. Additionally, Washington Court Rule 3.2 mandates that release decisions prioritize non-monetary conditions before imposing financial requirements that may result in incarceration solely due to poverty. Here, the prosecutor sought $10,000 bail, an amount Zahn's attorney noted was tantamount to a no-bail hold given his disability income and $100 maximum affordability. The court must weigh Zahn's prior felony harassment and strangulation charges against his documented mental health treatment, family support, and employment prospects. The defense's argument that alternative causes existed for the noise, a whip making loud sounds, directly challenges the probable cause foundation. Yet the stipulation allowed the arraignment to proceed without evidentiary testing of this claim. This exchange illustrates how bail hearings often become proxy battles over pretrial detention, where financial capacity rather than dangerousness determines liberty. Courts that ignore ability to pay considerations risk violating constitutional protections against excessive bail under the Eighth Amendment and Washington's more protective state constitutional provisions, perpetuating a two-tiered system where poverty itself becomes punishable.
We would request conditions of no law violations and that the defendant not possess any firearms, dangerous weapons, no BB or pellet guns, or any other projectile weapons fired by spring or compressed.
And any of this related, the felony case, I'm taking not related as to the.
Correct, Your Honor. I believe that, if my memory is correct, that appeared to be a domestic violence crime. This person had no, the victim in this case did not even know who the defendant was. There was no connection, at least not that we're aware of.
Your Honor, we are asking for release on his personal recognizance. Understand that he does have criminal history before the charges last year. The last offense was from 2019. He is fighting those charges from last year. He can only afford around $100 in bail, so any amount over that is tantamount to a no bail hold. He has been going to mental health treatment through BHR once a month. And he was doing treatment before through Northwest Resources, but he's been unable to do that lately in order to find work and focus his efforts on fighting that Superior Court matter. He does live with his parents who are very supportive, and so he does have ties to the community to ensure that he makes his new court hearing, and he does have a job that he was supposed to start tomorrow. And so we asked that he be released on his personal recognizance. The airsoft gun was found downstairs in the home where my client was allegedly upstairs firing it. My client, Mr. Zahn, did have also a whip in the upstairs, which makes a loud noise as well when it's used. And so there was a possibility for other causes for the noises that were heard. And so we are asking for his release on his personal recognizance.
And you were able to get contact information, mailing, text message reminder?
Yes, Your Honor, I'll send those to the clerk.
Mr. Zahn, I'm going to have you post bond to ensure that you come back and ensure that you don't commit further violent crimes here, pending what's pending trial and what you've been convicted of in the past. And hear the allegations. Tell me that you're a risk to reoffend in a violent way against others. So I'm going to have you post a $10,000 cash for bond bail.
Can it be lower than that? Because
No, I'm not debating it with you, sir. 10,000 cash for bond bail.
Right.
And if you make bail, you come back to court, you don't violate the law, you don't possess any firearm, you don't possess a BB gun or a pellet gun or anything of that nature that date, I'll set April 7th, put things up sooner. Also need to get it on the trial track.
The judge rejected Zahn's request for reduced bail, setting $10,000 cash bond despite his demonstrated inability to pay, citing his criminal history and alleged risk of violent reoffending. The court then established trial scheduling and began addressing protective order conditions. Washington's pretrial release statute, RCW 10.19.050, authorizes courts to impose conditions reasonably necessary to protect community safety and ensure appearance, including no-contact orders and weapons prohibitions. The Washington Supreme Court in State v. Smith, 2018, clarified that trial courts possess broad discretion in bail determinations, but this discretion must still operate within constitutional constraints against excessive bail and equal protection guarantees. Furthermore, Washington Court Rule 3.2c, 3 specifically permits no-contact orders as release conditions when there is reason to believe the defendant poses a risk to specific individuals. The judge's refusal to reduce bail, despite Zahn's $100 maximum capacity, reflects a prioritization of public safety concerns over financial equity considerations. The court's subsequent inquiry about no-contact conditions with William Lindquist demonstrates procedural adherence to Rule 3.2, though defense counsel raised a practical complication. Zahn claimed no knowledge of Lindquist's identity, creating risk of inadvertent violation. The weapons prohibition extending to BB and pellet guns addresses the specific alleged conduct, while acknowledging the prosecutor's concern about Zahn's access to projectile weapons. This judicial response reveals the tension between individualized risk assessment and standardized bail practices. When courts set bail amounts functionally unattainable for indigent defendants, they effectively impose pretrial detention without the procedural protections required for such confinement, potentially compromising the presumption of innocence and creating pressure for plea agreements, regardless of actual guilt.
At what time? So April 7th, 8:30. Remember, we can always set it sooner if you. Mr. Zahn,
Because you're under imposing a condition, no contact with the victim.
I didn't have.
I
that.
didn't request a specific anti-harassment order, but just
Okay.
as a general release condition.
All right, didn't hear that. Any issue with not having contact with William
I didn't even know
Lundquist?
the guy, so.
He doesn't know who that individual is. So the only concern would be that he would inadvertently have contact because he has no idea who that individual is.
Okay, and how would you spell that last name?
LIND as in David, QUI.
All right, no intentional or knowing contact with a William Lindquist as part of your release. So on that, we'll be back April 7th and that's all for today.
Am I good?
You're good.
All right, thank you.
Somebody had a copy. Nope. Okay.
The court set Christopher Zahn's bail at $10,000 cash, an amount he cannot afford, ensuring his pretrial detention unless he secures release through other means. His trial was scheduled for April 7, 2026 at 8:30 a.m., with release conditions prohibiting intentional or knowing contact with William Lindquist and banning possession of all firearms, BB guns, pellet guns, and similar projectile weapons. Zahn qualified for appointed counsel through Pacific Point Defense, and his attorney may file for bail review in Superior Court, given the municipal court's jurisdictional limits on modifying its own orders. This arraignment exemplifies a systemic crisis in American pretrial justice: the transformation of bail from a mechanism ensuring court appearance into a tool of wealth-based detention. Washington's framework, while nominally protective, still permits outcomes where indigent defendants face incarceration solely for their poverty. The Blazina Court's recognition that ability to pay must factor into bail calculations remains inconsistently implemented, as demonstrated when judges set amounts defendants explicitly cannot meet. The practical consequence, jail cells filled with legally innocent but financially poor individuals, undermines both constitutional promises and public safety research showing that brief pretrial detention increases recidivism risks. For viewers, this case illuminates why bail reform movements emphasize risk assessment tools, supervised release programs, and mandatory consideration of financial capacity. The law on paper guarantees liberty before conviction. The law in practice often delivers detention through price tag. Understanding this distinction is essential for meaningful engagement with criminal justice policy. If you found this case analysis valuable, subscribe for weekly deep dives into courtroom proceedings that reveal how legal principles actually operate in practice. Share this video with anyone interested in criminal justice reform, and comment below with cases or legal concepts you'd like to see explained. Your engagement helps make the legal system accessible to everyone, not just those who can afford it.